Perfecting a security interest. A security interest must have attached under UCC subsection 9203, as discussed in Chapter 2, before it may be perfected. Perfection of a lien under Article 9 is generally effectuated in one or more of four ways: automatically, filing a financing statement, taking possession, or obtaining control. Often a lien may be perfected in more than one of these ways, but one of the ways will provide greater protection and priority than the other. For example, a lien may be perfected in chattel paper by filing a financing statement or by taking possession, but if the secured party chooses to perfect the lien by filing only, it may not have priority over subsequent purchaser who takes possession without knowledge that his actions violate the first lien holder's lien. Thus, when a lien may be perfected in more than one way, it is generally advisable to perfect the lien in multiple ways, or if that is not possible, to perfect the lien in the way that is most protective of the secured party. Automatic perfection is not the norm. Generally, a purchase money security interest, PMSI, in consumer goods is automatically perfected. A few of the other cases in which perfection is automatic include assignments of accounts or payment intangibles that are not a significant part of the outstanding account, or payment intangibles. Healthcare insurance receivables assigned to the provider of the healthcare goods or services. 3. Sales of payment intangibles and promissory notes, estates, and supporting obligations, ergo letters of credit. The few cases of automatic perfection also include the few cases in which perfection is temporary. A security interest in certificated securities, negotiable documents, or instruments is perfected without filing or taking of possession for a period of 20 days from the time it attaches to the extent that it arises for new value given under an authenticated security agreement. A perfected security interest in a negotiable document or goods in possession of a bailee, other than one that has issued a negotiable document for the goods, remains perfected for 20 days without filing if the secured party makes available to the debtor the goods or documents representing the goods for the purpose of ultimate sale or exchange, or loading, unloading, storing, shipping, transshipping, manufacturing, possessing, or otherwise dealing with them in a manner preliminary to their sales or exchange. A perfected security interest in a certificate, security, or instrument remains perfected for 20 days without filing if the secured party delivers the security, certificate, or instrument to the debtor for the purpose of ultimate sale or exchange, or presentation, collection, enforcement, renewal, or registration of transfer. Upon expiration of the 20-day period above, the usual rules of priority govern. A lien in proceeds continues for 20 days and perhaps longer as provided in UCC subsection 9315. In the balance of cases except for money, which must always be possessed, if the collateral is tangible or quasi-tangible, i.e., non-electronic chattel paper, the lien may generally be perfected through filing or possession. If the collateral is intangible, i.e., accounts, the lien must be perfected through filing except in the case of deposit accounts. Electronic chattel paper and letters of credit rights in which the lien must be perfected by control. In the case of investment accounts, the lien may be perfected by filing or control. These are the only generalizations, however, and the specific perfections rules are set forth more fully below. To determine how to perfect a lien, you must first determine the type of collateral you are working with, as defined by Article 9. In most cases, determining the type of collateral is simple. In some cases, however, determining the type of collateral may be difficult. And, indeed, the collateral may potentially fall into two or more categories. If the collateral may fall into two or more categories, the secured party should perfect as required for each of the potential types within which the collateral may fall. In larger transactions, a secured party should further consider obtaining an attorney's opinion, letter, or insurance on issues of perfection, and even attachments and priority. Insurance will generally be considered a credit enhancement, but an attorney's opinion letter will probably not. Finally, as noted above, consignments are also covered by Article 9, and the consignor must comply with the perfection requirements, even in the case of a true consignment. A. Types of collateral. Section 9102A provides specific definitions for many types of collateral. These definitions range from accounts to payment intangibles and from crops to equipment. Account. The right to payment of monetary obligation, whether or not earned by performance, for property sold, leased, licensed, assigned, or otherwise disposed of, for services rendered to or to be rendered under an insurance policy issued or to be issued, for energy for hire of a vessel arising out of the use of a credit card, winnings in the lottery, i.e. accounts receivable, credit card receivables, possibly revenues from the sales of or license of software. Accounts include health care, insurance, receivables. Rights to payment excluded from accounts are rights to payment evidenced by chattel paper or an instrument. Commercial tort claims, deposit accounts, investment property, letter of credit rights, or letter of credit, and rights to payment for money or funds advanced or sold, other than rights arising out of the use of the credit card or change card. Note: a seller of an account does not retain any interest, legal or equitable. This revision to Article 9 was designed to overrule Octagon Gas System, Inc. versus Remier in regards to Meridian Reserve Incorporated, 995 F2D 948, 10th Circuit Court, 1993. Account seller retained an interest that was a part of the bankrupt estate. The seller is, however, still deemed to have the rights. It's sold until the buyer perfects its interest, so that a second buyer without knowledge of the first sale may take good title. Note: the definition of accounts was substantially enlarged under revised Article 9. Under the old law, accounts only included the right to payment for goods sold or released or for services rendered. The new definition includes inter alia, the right to payment for property sold, leased, licensed, assigned, or otherwise disposed of, and the right to payment for money or funds advanced arising from out of the use of credit card. Funds is a broader concept than money, the letter of which is essentially limited to currency under UCC subsection 1-201. As a result, accounts now include many items that would have been general intangibles under the old law, and even many that would have otherwise fallen into the new subcategory of payment intangibles. Indeed, under the law, you can have a certain right that are bifurcated, with part of the right being an account and the other parts being a general intangible. By way of example, the right to payment under a software license agreement will now be an account, but the general ownership and rights of the license are general intangibles. Healthcare insurance receivables. A claim under a policy of insurance for healthcare goods or services provided does not include Medicare or Medicaid, because healthcare insurance receivables are a subcategory of accounts. They have the same exceptions, such as sales in connection with the sale of a business. Because the payer on a healthcare insurance receivable is an insurance company and other law governs same. Healthcare receivables are excluded from the rules addressing account debtors' rights and duties. Other types of insurance claims are not covered by Article 9 except to the extent they may be proceeds. Agricultural lien, an interest other than a security interest in farm products which secure payments or performance of an obligation for goods or services furnished in connection with a debtor's farming or operation, or rent on real property leased by a debtor in connection with its farming operation, which is created by statute in favor of a person that, in the ordinary course of business, furnish goods or services to a debtor in connection with a debtor's farming operation, and whose effectiveness does not depend on the person's possession of the personal property. As extracted collateral, oil, gas, or other minerals that are subject to a security interest that is created by a debtor having an interest in the materials before extraction and attached to the minerals as extracted, or B, accounts arising out of the sale at the wellhead or minehead of oil, gas, and or other minerals in which the debtor had an interest before extraction. Note, this is a very tricky definition. Oil, gas, and other minerals not yet extracted from the ground are real property, and thus Article 9 does not apply. Oil, gas, and other minerals that have been fully extracted before the debtor acquires an interest in them, such as coal purchased by a manufacturer, are goods under Article 9. As extracted collateral exists only where the debtor had an interest in the collateral before extraction and the security interest attaches as the collateral is extracted. That is, as the oil, gas, and other minerals pass from the real estate to goods. Chattel paper, a record or records that evidence both a monetary obligation and a security interest in goods, i.e. equipment finance agreement, promissory notes with security agreements, conditional sales agreements. If a transaction is evidenced by a series of instruments, the group of instruments constitutes the chattel paper. Note, when chattel paper includes a negotiable instrument, enforcement is governed by Article 3, not Article 9. Because Article 9 excludes from the definition of account debtor persons obligated to pay a negotiable instrument, even if the instrument constitutes part of chattel paper. Thus, UCC subsection 9403, 9404, and 9406 do not apply when chattel paper include a negotiable instrument. Note also, under the 2010 amendments and assignments of the payment stream of chattel paper will also constitute chattel paper and not a payment intangible. See payment intangible infra. Characters of vessels are expressly excluded from the definition of chattel paper and are expressly included in the definitions of accounts. Note, chattel paper can include not only obligations secured by goods, but also by software, to the extent that the software is sold or leased in an integrated transaction together with specific goods. Number 5, commercial tort claim. A claim by an organization or a claim by an individual arising out of a business or profession for non-persona injury. Consignment, a transaction regardless of its form in which a person delivers goods to a merchant for the purpose of a sale, and the merchant deals in goods of that kind under a name other than the name of the person making delivery, is not an auctioneer, and is not generally known by its creditor to be substantially engaged in selling of the goods of others. With respect to each delivery, the aggregated value of the goods is $1,000 or more at any time of delivery. The goods are not consumer goods immediately before delivery, and the transaction does not create a security interest that secures an obligation. Consignments are often inventory under Article 9, and thus a secured party must be sure to not only perfect its position, but also that to comply with the inventory special timing and notice provision. Crops, see Farm Product Info. Deposit accounts, a demand time savings passbook or similar account maintained by a buyer with a bank. A deposit account evidences by an instrument is subject to the rules applicable to instruments generally. As a consequence, a security interest in such an instrument cannot be perfected by control. See sections 9104, and the special priority rules applicable to deposit accounts. See sections 9327 and 9340 do not apply. The terms deposit accounts does not include investment properties such as securities and security entitlements. Thus, the term also does not include share in a money market mutual fund. Even if the shares are redeemable by check, accounts evidenced by an instrument or a security interest in a deposit account in a consumer transaction, except with regards to proceeds of other collateral deposited into the account, are excluded from the term deposit account or deposit accounts. Deposit accounts include uncertificated certificates of deposit, assuming no writing evidence the bank's obligation to pay, but a non-negotiable certificate of deposit which may be certificated is a deposit account only if it is not an instrument, which will depend on whether it is of a type that is the ordinary course is transferred by delivery with an endorsement or assignment. Because deposit accounts are now a separate and specific collateral category, the security agreement must specifically state deposit accounts, and a secured party may not rely upon the reference to general intangibles. Documents. A document of title or a receipt as described in UCC subsection 72012, i.e. bills of lading, warehouse receipts, dock warrants, dock receipts. Fixtures. Goods that have become so related to particular real property that an interest in them arises under real property law. Equipment may not be a fixture even if it is installed in real estate. Note that certain trade fixtures, which are readily removable machines and equipment, are treated differently under Article 9 than traditional fixtures. General intangibles. This is a catch-all. It includes any personal property not included in the other categories and oil, gas, and other minerals before extraction. Examples are various categories of intellectual property and the rights to payment of a loan of funds that is not evidenced by chattel paper on an instrument. A. Items that have been determined to be general intangibles include the following: rights of payments that does not come within the definition of accounts. Note that does not come within the definition of an instrument. Interest in real estate contracts, unregistered copyrights, proceeds of settlements of a breach of contract or tort action, construction bonds. Dominion name, covenant not to compete, interest in a management contract, patents, patenter's interest in partnership, termination fees, trademarks, members' interest in an LLC, and interest in a partnership or LLC is not, however, a general intangible, but is a security under Article 8 if the LP or LLC interest is default in or traded on securities exchange or is in securities market. Its term expressly provides that it is a security governed by the UCC Article 8, i.e. the LP or the LLC has elected to opt in to the UCC Article 8 rules governing securities. The LP or LLC interest is an investment company security under the federal investment company laws, or the LP or LLC interest is held in a brokerage or similar securities account. See UCC subsection 8-103C. Liquor license. The issue of whether security interest and liquor license are within the scope of Article 9 is really a non-code issue, depending on whether the local law permits such liens. Before the 1999 revisions to the Article 9, state statutes often placed additional restrictions on the assignments of liquor licenses as collateral, such as approval by the regulatory body, unless those supplemental statutes have been rewritten since the adoption of the revision. They are overridden by the UCC subsection 9408C. Although several state courts have taken the position that no security interest can attach to a liquor license or that liquor licenses are not property, the FCC license note that the security interest may be limited to the private right to receive economic value, but not attached directly to the FCC license itself. State and federal permits and licenses, cooperative apartments, and tax refunds. The definition of accounts was substantially, I'm missing a word there. Under revised Article 9, under the old law, accounts only included the right of payment for goods sold or leased or for services rendered. The new definition includes inter alia, the right to payment for property sold, leased, licensed, assigned, or otherwise disposed of, and the right to payment for money or funds advanced arising out of the use of a credit card. Funds is a broader concept than money, the latter of which is essentially limited to currency under the UCC subsection 1-201. As a result, accounts now include many items that would have been general intangibles under the old law, and even many that would have otherwise fallen into the new subcategory of payment intangibles. Indeed, under the new law, you can have certain rights that are bifurcated, with part of the right being an account and other parts being a general intangible. By way of example, the right to payment under the software license agreement will now be an account, but the general ownership and right of a license are general intangibles. Under revised Article 9, commercial tort claims, deposit accounts, and a letter of credit rights were excluded from the definition of general intangibles. As a result of this exclusion, tort feasors, commercial tort claims, banks, deposit accounts, and person obligated on letters of credit rights are not account debtors, having the right and obligations set forth in Section 9404, 9405, and 9406. Thus, tort feasors, banks, and persons obligated on letters of credit are not obligated to pay an assignee's secured party upon the receipt of the notification described in Section 9404A. See comment 5. Payment intangibles. General intangibles under which the debtor's principal obligation is monetary, i.e. the right to payment under a loan or fractional share of a loan without an instrument or chattel paper, the right to payment under a structure settlement, including form the destruction of collateral, Payment intangible is a subset of the definition of general intangibles. Virtually any intangible right could give rise to a right to payment of money. Once one hypothesizes, for example, that the account debtor is in breach of its obligation, the term payment intangible, however, embraces only those general intangibles under which the account debtor principal obligation is a monetary obligation. A right to the payment of money is frequently buttressed by ancillary rights, such as rights arising from covenants in a purchase agreement, note, or mortgage requiring insurance on the collateral or forbidding removal of the collateral, rights arising from covenant to preserve the creditworthiness of the promisor. Article 9 does not treat these ancillary rights separately from the right to payment to which they relate. For example, attachments and perfection of an assignment of a right to payment of a monetary obligation, whether it be an account or payments intangible, also carries these ancillary rights. Goods, all things movable, including fixtures, timber to be cut and removed, and farm products. Ascension, goods that are physically united with other goods in such a manner that the identity of the original goods is not lost. Consumer goods, goods used or bought for the use primarily for personal, family, or household purposes. Crops, includes crops grown, growing, or to be grown, even if the crops are produced on trees, vines, or bushes. Equipment. Equipment is a difficult category. It includes all goods other than inventory, farm products, or consumer goods, i.e. computers, office furniture and equipment, non-titled machinery, and taxi medallions. Farm products. Other than standing timber with respect to a farming operation and are crops grown, growing, or to be grown, including crops produced, or trees, vines, and bushes, adequate goods, livestock, born or unborn, including adequate supplies in a farming operation, or product of crops or livestock in an unmanufactured state. Inventory, goods other than farm products for sale or lease, including raw materials, work in process, or materials used or consumed in business. Note, inventory includes new materials and materials used or consumed in business. Thus, inventory can include items not held for sale or lease. Titled vehicles can also be inventory. See how to perfect in various types of collateral. Titled vehicles, subsection infra. Manufactured homes, a structure transportable in one or more sections, which, when erected on site, is 320 or more square feet and designed to be used as a dwelling, can be consumer goods. Standing timber to be cut, removed under the conveyance or contract for sale. Instruments, a negotiable instrument or any other writing that evidences a right to a payment of a monetary obligation is not itself a security agreement or a lease, and is of a type that is in the ordinary course of business transferred by delivery with any necessary endorsements or assignments. The term does not include investment property, letters of credit, or writings that evidence a right to payment arising out of the use of a credit or change card or information contained on or for use with the card. Except in the case of chattel paper, the fact that an instrument is secured by a secured interest or encumbrance on property does not change the character of the instrument. Promissory note, an investment that evidences a promise to pay a monetary obligation does not evidence an order to pay, i.e. check, and does not contain an acknowledgement by a bank that the bank has received for deposit a sum of money or funds. does not include checks, CDs, or a note with a security agreement, which is chattel paper. Investment property, a commodity account, commodity contract, a security, whether certificated or uncertificated, a security entitlement, or a securities account, i.e. stock accounts, money market accounts. Broker, a person engaged for all or part of his time in the business of buying and selling securities, who in the transactions concerned acts for, buys securities from, or sells a security to a customer. Nothing in this Article 8 determines the capacity in which a person acts for the purpose of any other statute or rule to which the person is subject. Uncertificated security, a share, participation, or other interest in property of an enterprise of the issuer or an obligation of the issuer which is not represented by an instrument and the transfer of which is registered upon books maintained for the purpose on behalf of the issuer of a type commonly dealt in on securities exchange or markets, and either one of a class or series, or by its terms divisible into a class or series of shares, participations, interest, or obligations. Certificated security, a share, participation, or other interest in property or of an enterprise of the issuer or an obligation of the issuer which is represented by an instrument is issued in bearer or registered form. Of a type commonly dealt in on securities exchange or markets, or commonly recognized in any area in which it is issued or dealt in as a medium for investments, and either one of the class or series or by its term divisible into a class of series or shares, participation, interest, or obligation. Registered form. A certificated security is in registered form if it is specified a person entitled to the security or the right it represents, and its transferred may be registered upon books maintained for the purpose by or on behalf of the issuer or the security so states. Bearer form. A certificated security is in bearer form if it runs to bearer according to its term and not by reason of any endorsement. Commodity account. An account maintained by a commodity intermediary in which a commodity in which a commodity contract is carried for a commodity customer. Commodity contract. A commodity futures contract, an option on a commodity futures contract, a commodity option, or another contract is the contract option is a trade on a subject to the rules of a board of trade that has been designated as a contract market for such a contract pursuant to federal commodities laws, or B, traded on foreign commodity board or of trade, exchange, or market, and is carried on the books of a commodity intermediary for a commodity customer. Commodity customer, a person for which a commodity intermediary carries a commodity contract on its books. Commodity intermediary, a person that is registered as a futures commission merchant under federal commodities law, or B, in the ordinary course of its business provides clearance or settlement service for a broad or board of trade that has been designated as a contract market pursuant to the federal commodities law. Securities account, an account to which a financial asset is or may be credited in accordance with an agreement under which the person maintaining the account undertakes to treat the person for whom the account is maintained as entitled to exercise the rights that compromise the financial asset. Securities intermediary means a clearing corporation, or a person including a bank or a broker that in ordinary course of business maintains security accounts for others and is acting in that capacity. Securities entitlement, the rights and the property interest of an entitlement holder with respect to a financial asset specified in Part 5. Letter of credit means a right to payment or performance under the letter of credit, whether or not the beneficiary has demanded or is at the time entitled to demand payment or performance. The term does not include the right of a beneficiary to demand payment or performance under the letter of credit. This definition is consistent with Article 5, which authorizes assignments of the beneficiary's rights to the proceeds with the consent of the issuer. Proceeds does not include drawing rights. Electronic letters of credit are included with Article 9. A secured party can become a transferee of the letter of credit instead of just the secured party, in which case, as transferee, it can obtain the rights to enforce payment. The rights of the transfer beneficiary are independent of the superior to that of a secured party that has obtained control over the letter of credit. Article 9 only applies when the assignment to the right to proceeds is for the security interest. Article 9 does not apply to a transfer of the right to draw, whether it is as a security interest or a sale. Litigation rights. A breach of a contract claim in litigation is likely to be a general intangible, not a commercial tort claim. Many times litigation will include contract and tort claims. If there is any doubt about the nature of the claims, the secured party should be sure to comply with the specific requirements for obtaining a security interest in a commercial tort claim. See Chapter 2A, Supra. Of course, the secured party should also be sure to perfect against both commercial tort claims and general intangibles, including both in the financial statements. It must be further noted that once litigation is reduced to a judgment, Article 9 does not apply to the assignment of the interest in a judgment unless the original collateral was the right to the proceeds of the litigation. Finally, if the claim in the litigation was not a commercial tort or a breach of contract claim, but was a personal injury claim, it would not have been the subject of an original collateral claim and can only become subject to Article 9 when and if the claim is settled and becomes an obligation to pay, at which time it is a payment intangible. See UCC subsection 9109, comment 15. Thus, a secured party cannot obtain a security interest under Article 9 in a personal injury case unless and until it has settled and become an obligation to pay. And a secured party cannot obtain a security interest in a judgment unless it is the result of an original collateral claim or it has been settled and become an obligation to pay. Lottery prize, see accounts. Proceeds means the following property, whatever is acquired upon the sales, lease, license, exchange, or other dispositions of collateral, whatever is collateral on or distributed on account of collateral, rights arising out of the collateral to the extent the value of collateral, claims arising out of the loss, nonconformity, or interference with the use of defects or infringements of rights in or damages to the collateral, or the extent of the value of the collateral and the extent payable to the debtor or the secured party, insurance payable by reason of the loss of nonconformity of defects or infringements of rights in or damage to the collateral. Software. Computer program and any supporting information. The term does not include a computer program that is embedded in goods. If the computer program is embedded in goods, the collateral is then treated as goods for all purposes. Software is embedded if the program is associated with the goods in such a manner that it is customarily is considered part of the goods, or by becoming the owner of the goods, a person acquires the rights to use the program in connection with the goods. The software is not to be deemed part of the goods if the software is embedded in goods that consist of solely of the medium in which the program is embedded. Thus the software that runs various aspects of the car is embedded in such a way that it is not separate collateral from the car. The car and the software together are goods. Conversely, a desktop computer and its operating system are not one, but two separate categories of collateral, namely goods and software, general intangibles. Trade secrets and intellectual property rights in connection with software are general intangibles. Revenues from the sales or license of software are accounts or proceeds of copyrights and or patents. Supporting obligations. A letter of credit right or secondary obligation that supports payments or performance of an account. Chattel paper. A document. A general intangible. An instrument or investment property. Title vehicle. Motor vehicle subject to a certificate of title statute. Certificate of title means a certificate of title with respect to which a statute provides for the security interest in question to be indicated on the certificate as a condition or result of the security interest obtaining priority over the rights of a lien creditor with respect to the collateral. Timber to be cut, see goods supra. Virtual currency. A distinction must be noted between virtual currency and real currency. Real currency is coin and paper money of the United States and any other country that is designated as legal tender, circulates and is customarily used and accepted as a medium of exchange in the country of issuance. Virtual currency does not have legal tender status. Non-uniform amendments. Some states have created a special class of collateral through non-uniform amendments. For example, New York has created a class for cooperative through the 1988 non-uniform amendment, which was incorporated into the 2001 revisions. The amendment requires a cooperative addendum to be filed with financing statements. B. However, to perfect in various types of collateral. Applicable law. Generally, the law of jurisdiction in which the debtor is located governs perfection. The effect of perfection or non-perfection and priority. Where, however, perfection is effected through possession, the law of the jurisdiction in which the collateral is located governs perfection. The effect of the perfection or non-perfection and priority. But for non-promissory security interest in negotiable documents, goods, instruments, money, and or tangible chattel paper, the local law of the jurisdiction only governs perfection for goods of fixtures and timbers to be cut. And the local law governs the effect of perfection or non-perfection and the property of non-possessory security interest in collateral. With respect to deposit accounts, the local law of a bank's jurisdiction governs perfection, the effect of perfection or non-perfection and priority. The suits of the bank's jurisdiction may be agreed between the parties in their agreement. The rule is somewhat similar for investment accounts. The governing law for the letters of credit is generally the issuer's jurisdiction or a nominated person's jurisdiction, with the exception of deposits accounts and investment accounts. The Article 9 rules governing perfection and priority apply independently of any collateral law provision because the parties may not contractually modify the right of third parties such as other secured creditors. Notably, in designating the jurisdiction whose law governs, Article 9 directs the court to apply only the substantive local law of particular jurisdiction and not its choice of law rules. A security interest in each of these categories may be perfected as follows. Accounts filing UCC subsection 9310A. Exceptions. Accounts that are not a significant part of an outstanding account. Perfection is automatic. Subsection 93092. Healthcare insurance receivables assigned to provide of healthcare goods or services. Perfection is automatic. Subsection 93095. Agricultural liens filing UCC subsection 9310A. Annuity contracts. If not insurance policies, annuities are general intangibles. See general intangibles, infra 300. Assignments for the benefit of a creditor. Subsection 930912. As extracted collateral, filing note that the filing, like a fixture filing, must be made with the office in which a mortgage would be filed on a real estate and must include additional information. UCC subsection 310A, UCC subsection 9501A, 1A, and 9502B. Certificate of deposit, CDs. A CD is generally either a deposit account or an instrument, depending upon whether it is of a type that is the ordinary course of business, is transferred by delivery with any necessary endorsements or assignments. If the CD is so transferable in the marketplace, it is an instrument even if the language on it states otherwise. If the CD is not transferable by delivery with any necessary endorsement or assignment, it could be a deposit account. See instruments and deposit accounts infra. Chattel paper, filing or possession, UCC subsection 9312A and 9313A. If a secured party chooses to perfect through filing instead of a possession, it is at risk of losing its priority unless the chattel paper is marked to evidence the secured party's security interest. See UCC subsection 93030A, B, and F. The secured party will, however, prevail over the trustee in the bankruptcy with just a filing, UCC subsection 9312A and 9330. Electronic chattel paper, filing or control, UCC subsection 9312A and 9314A, as well as 9105. Commercial tort claims, filing UCC 9310A. Consignment, filing a notice for inventory, UCC subsection 9310A and 9324B. Consignments are often inventory under Article 9, and thus a secured party must be sure not only to perfect its position, but also to it comply with the inventory special timing and notice provisions. Copyrights. Unregistered copyrights are general intangibles. Filing UCC 9310A, registered copyrights are not general intangibles and are governed by federal law. For registered copyrights, a note or memorandum must be filed with the U.S. Copyright Office. The secured party would be wise to file a financing statement as well. Crops, filing a possession, see goods infra. While crops do not require a county filing like a fixture filing, timber does require such a filing. See goods standing timber infra. Deposit accounts, control under UCC 9104 9314A. Secured party is a depository bank. When the secured party is a depository bank, it is automatically deemed to be in control and thus perfected. UCC subsection 9104A1. Secured party is not depository bank when the secured party is not the depository bank. The secured party, the debtor, and the bank must enter into a control agreement, UCC subsection 9104A2, or the secured party must become a customer on the account, UCC subsection 9104A3. Due to the depository bank secret lien, even when a secured party, non-depository bank, obtains a control agreement, it should also obtain a waiver from the depository bank of its right of set-off and recoupment, and obtain a subordination form from the depository bank or become the bank's customer. See priorities in liens section infra. Documents. Negotiable. Filing a possession UCC subsection 9312A, a 9313A, a document is negotiable if, by its terms, the goods are to be delivered to bearer or to the order of a named person. UCC subsection 7104B, 1041B, all other documents are non-negotiable. Under California law, however, any negotiable documents must be conspicuously marked as non-negotiable, or the holder who purchased it for value with the understanding it was negotiable may treat it as negotiable as to a bailee. Goods covered by negotiable document. While goods are in the possession of a bailee that has issued a negotiable document covering the goods, a secured party may perfect a security interest in the goods by perfecting a security interest in the documents. A secured interest perfected in the document has priority over any security interest that becomes perfected in the goods by another method during that time. A secured party that perfects through filing only risks losing its priority to one who subsequently takes possession. The secured party will, however, prevail over a trustee in a bankruptcy with just filing a UCC subsection 9312A. Non-negotiable. Issuance of documents in name of secured party bailees, receipt of notification, or filing as to goods. UCC 9312D. Goods covered by non-negotiable documents. While goods are in the possession of the bailee that has issued a non-negotiable document covering the goods, a security interest in the goods may be perfected by 3A1, issuance of a document in the same name of the secured party. 3A2, the bailee's receipt of notification of the secured party's interest. Or 3A3, filing as to the goods. Documents containing two of the Article 9's few secret temporary liens, first with negotiable documents, instruments, and certificated securities. A secured party that gives new value pursuant to a written security agreement has a perfected lien for 20 days without filing UCC subsection 9312E. Second, with negotiable documents or goods in possession of the bailee without a negotiable document, the security interest remains perfected even when the secured party gives the debtor the goods or the document representing the goods for the purpose of ultimate sale or exchange, or loading, unloading, sorting, shipping, transshipping, manufacturing, possessing, or otherwise dealing with them in a manner preliminary to their sale or exchange. UCC subsection 9312F 1 and 2. With goods in possession of a bailee with a non-negotiable document, the secured party should 1. File as to the goods, 2. Notify the bailee of the secured party's interest, 3. Arrange the documents to be issued in name of the secured party. UCC subsection 9312D. Estates, automatic. UCC subsection 930913. Notify the executor or administrator and obtain an acknowledgement of the notification of the lien. A secured party with an interest in the estate should have the debtor sign a security agreement before a notary to assure priority. Remember, there may be priority unknown liens because perfection is automatic. Fixtures, filing. Note that with with the exception of Louisiana, a fixture filing must be made with the office in which a mortgage would be filed on the real estate and must include additional real property related information. UCC subsection 9310A, 9501A, 1B, and 9502B, a mortgage that satisfies the requirements of section 9502C is also effective as a fixture filing. A filing for certain trade fixtures, readily removable equipment, and machinery does not need to be filed in the office in which a mortgage must be filed. A regular centrally filed financing statement is sufficient, UCC section 8334E2. Thus, there are three ways to file against fixtures for non-trade fixtures: a fixture filing or mortgage satisfying the requirements of UCC subsection 9502C must be filed for certain trade fixtures, and ordinary filing is all that is required. Financing agreements, franchise agreements. Franchise agreements are general intangibles. See general intangibles. General intangibles filing, UCC subsection 9310A. Real estate related contracts, Article 9 does not apply to real estate, but applies to the promissory notes related to real property. UCC subsection 9109D, 11A, and 9203G, and 9308E. General intangibles may include other real estate contracts such as a purchase-sale contract, option contract, licenses, and permits. If these documents are not pure real estate contracts, they may be considered accounts. Accordingly, it is prudent in these cases to record a real property assignment and file a financing statement. Copyright, patent, and trademarks, as noted in this section and in Chapter 1, Supra, Article 9, does not apply to registered copyrights, but does apply to unregistered copyrights, patents, and trademarks, as is also noted above in this section and in the Chapter 1. Unregistered copyrights should generally be registered and then filed against at the federal level. Federal filings should also be made against patents and trademarks. See copyright, trademark, patents within the section of Chapter 1B, copyright, trademarks, and patents, and footnotes 21 through 27, Supra. Payment intangibles, sales perfections and automatic, UCC 93093, payment intangibles that is not a significant part of a payment intangibles. Perfection is automatic, UCC subsection 93092. Pledge filings, UCC subsection 9310A. Goodwill. Goodwill is general intangibles. See general intangibles, Supra. Goods. Ascensions, filing or automatic, UCC 9310A, UCC subsection 9335A and B. Consumer good, filing or possession, UCC subsection 9310A, UCC subsection 9313A. However, there are exceptions. PMSI perfection is automatic, UCC subsection 93091. Assets subject to title statutes which are not in inventory, see titled vehicles infra. Crops filing or possession, UCC subsection 9310A, 9313A. Agricultural lenders must also be familiar and comply with the Federal Food Security Act. Equipment filing or possession, UCC subsection 9310A through 9313A. Farm product filing or possession with notice for PMSI and livestock, UCC subsection 9310A, 9313A, and 9324D. Inventory filing or possession with notice of PMSI, UCC subsection 9310A, 9313A, 9324B. As noted in the document section, Supra, while goods are in the possession of a bailee, a security interest in the goods may be perfected through perfection in the documents. Manufactured homes filing the filing can be effective for up to 30 years. UCC subsection 9310A 9515B. Exceptions. If state law requires a certificate or a title for ownership's perfect the security interest by filing against the title. A security interest perfected under a state title statute has priority over interest of an owner or lien holder of the real property. UCC subsection 9334E4. Standing timber to be cut and removed under the conveyance or a contract for sale. Filing and fixture filing. UCC subsection 9310A and 9502B. Unlike crops, standing timber requires a financing statement to be filed at the county level as well. Much like a fixture filing, standing timber to be cut is treated like a security interest related to real property. When completing the UCC1 form, check and complete the fixture box, item 13, and the manufactured home box, item 18. Income tax refund. Income tax refunds are general intangibles. See general intangibles. Instruments, filing or possession. UCC 9312A, 313A, temporary automatic. UCC subsection 9312E, new value, or subsection 9312G when made available to the debtor for sale or exchange or presentation, collection, enforcement, renewal, or registration or transfer. A secured party that perfects on an instrument through filing only risks losing its priority to one of the subsequently takes possession. To one who subsequently takes possession, unless the instruments is marked to evidence the secured party's security interest. UCC 9330D and F. The secured party does, however, prevail over the trustee in a bankruptcy with just a filing. UCC subsection 9312A and 9330. Promissory note. Sale. Perfection is automatic. Pledge. Filing a possession. UCC subsection 9312A and 9313A. Note. One should generally not perfect by filing only because you cannot sue without possession of the note, and cannot be holder in due course without possession. Two important concepts must be noted in connection with the promissory note and mortgages. First, the mortgage follows the note. Second, because the mortgage follows the note, Article 9 trumps the real estate mortgage law regarding priority of liens. Thus, where a note and mortgage were double pledged and creditor a perfected under Article 9 by taking possession of the original note and filing a UCC1, and creditor B perfected by filing a notice of the assignment of the mortgage in the real property recorded or the real property records. Creditor A had priority in the note and mortgage. Accordingly, when taking a lien in a note and mortgage, perfection under Article 9 is paramount, even though the mortgage clearly is an interest in real property, investment property. Certificated securities, temporary automatic possession, control, or filing. With that, I'm going to leave off on this. It's late this evening. Ladies and gentlemen, as you know, we're delving deep into the UCC. Going to start to show you guys how well over 89% of the mortgages out there today are all void. Not just voidable, but flat out void. And we're getting to that, but we've got to get through this hard-hitting information first. So thank you for bearing with me this evening. I'll pick back up tomorrow at some point or later on today, as it's well within the wee hours of the morning. So I'll pick up today at some point with the rest of this very hard-hitting information. Stay tuned, share with your friends and family. It's time to become awakened, to have an ascension of the mind and realize truly what has transpired to you and yours. And with that, I say, Have a wonderful morning, and God bless.